So according to the affidavit of facts in support of post-conviction petition, Kohberger wrote he was, quote, convinced to falsely confess to capital murder. Convinced to falsely confess to capital murder, and basically said that him and his family had these meetings with the defense counsel and that he was convinced that this was legally the right thing to do, even though he says he's not guilty. He says there was withholding of all exculpatory discovery, and he's talking about, he says, clumps of unknown hair found in Ethan Chapin's.
One clump of hair, that's it. That's the single piece of physical evidence Bryan Kohberger is now pointing to as proof that 4 young lives were taken by someone else. Not him. Not the man who pled guilty in a courtroom, under oath, in front of a judge who asked him point blank if he was guilty, and heard him say yes.
Are you pleading guilty because you are guilty?
Yes.
So let's ask the real question today. Do a few strands of unidentified hair found in a murder victim's hand actually undo a guilty plea? Or is this something else entirely? I've been following this case since the beginning. And if you're new here, stick around. Because by the end of this video you're going to understand exactly why legal experts are already calling this affidavit weak.
I don't think so. My very strong sense is this will go nowhere. Obviously, his claims are under this umbrella of ineffective assistance of counsel.
Why does the timing of this filing line up almost perfectly with a legal deadline?
Because there's a deadline, and I think it's like in September. Like, he had to file something by then or he would lose his chance. So it's kind of something that I was keeping an eye on, but I wasn't really sure he would do it, and this is the reason why.
Why the victims' families aren't panicking the way you might expect.
No, at first I was a little bit worried because there's a lot of angles at which you can attack, the truth. There's a lot of ways you can go in and say, hey, now that I've seen every bit of evidence, can I poke a little hole through there? Can I find a little place where they didn't have me covered? So I was worried that he would have something really good and juicy in there. And so when he writes like he's in 3rd grade. So when you can finally piecemeal what he's saying, and got to write it out, and it's like he needs a translator. But once you figure out what he's saying, there was nothing there. I mean, it was really, really a relief to know that he didn't have something that was big, because when you've done the crime, you would know how to find where there's little mistakes, where they've got things wrong, because you were there. So you could poke at those things, and I was just nervous about that.
Here's what we know. In his own handwritten filing, submitted from behind bars without a lawyer's help, Kohberger claims that hair recovered from one of the victim's hands, hair that was never conclusively matched to him, should have been enough to keep this case out of a plea deal and in front of a jury. On its face, that sounds like it could matter. A stranger's hair in a victim's hand at a quadruple homicide scene. That's the kind of detail true crime communities have obsessed over for years. But here's what nobody talks about when they see a headline like that. The defense already had this evidence. It wasn't hidden. It wasn't buried in some overlooked file. It shows up in the pretrial exhibit filings, months before the plea was ever signed. If you go back and pull the court record, there's a stipulated motion where this exact piece of debris is listed as a defense exhibit.
I got a chance to look at the affidavit that he submitted with his motion. And really the only thing that he talks about is a clump of hair. Like he references a clump of hair that supposedly Ethan had in his hands. Now, you look at it and you say, okay, well, did the defense talk to him about it, right? His defense counsel talked to him about it, or did the prosecution not give it to him? So you have to look at those things, right? So the prosecution did give it to him, because if you go back specifically, and I kind of pulled this stuff up on my phone, but if you go back and look at, it's the stipulated motion for the admission of additional exhibits as evidence at the trial, and it's a defense exhibit. And it shows debris from right hand of Ethan Chapin, which is what they're talking about as the hair. So the defense had it, right? They were aware of it.
Meaning his own legal team knew about it, reviewed it, and had the chance to raise it in front of a jury. And instead, a plea was entered. So ask yourself, if this evidence was always sitting right there in discovery, what exactly changed? What's actually new here? That's the part that should make you pause before assuming this is some smoking gun. Now let's talk about what unidentified hair actually means in a case like this, because true crime audiences here doesn't match the suspect and immediately think exoneration. But that's not how forensic testing works. Hair recovered at a chaotic crime scene involving 4 victims, first responders, and a physical struggle can belong to almost anyone. Unmatched doesn't mean unexplained.
So in the autopsy photos, you can see that there's some hair in Ethan Chapin's hand. Not in the autopsy photo, in the crime scene photos. I don't know that I would call it a clump. And the defense did know about that hair because I went back and looked in the filings and they knew about it. And that hair was tested and it did not come back to Bryan Kohberger's DNA, but it was never tested more to figure out whose hair it was.
It means untested further, which is a very different thing. And legal analysts who've handled post-conviction motions for years will tell you, an unidentified trace of biological material is common in violent crime scenes. It's rarely, on its own, enough to unravel a plea that was entered knowingly, voluntarily, and on the record. Which brings us to the part of this story I think is the most important. And the part almost every other video on this topic is skipping. A guilty plea isn't just a formality. It's a legal event with its own protections built in specifically to prevent this kind of reversal. Before Kohberger ever stood up and admitted guilt, a judge walked him through a series of direct questions.
Obviously, probably will not carry, I would say, much weight, given the fact that Judge Hippler went through with him during his guilty plea, extensively to make sure individually on a basis with that his plea was knowing and voluntarily given.
Was he taking any medication that could affect his judgment? Did he understand what he was giving up? Was he satisfied with his legal counsel? And, most critically, was he pleading guilty because he was, in fact, guilty? He answered yes to all of it, in open court, on the record, under oath. That's not a technicality. That's the entire foundation the appeals process now has to try to knock down. And under the law, there are really only a small number of ways to challenge a plea like this after the fact.
Well, I wanted to get some more information on it, right? I wanted to see what his basis was. And, really, when you take a guilty plea, because you're in front of a judge, you have your lawyers present, you're sitting there, the judge is asking you all of the things that need to be asked. Are you doing this voluntarily, intelligently, and knowingly? Have you taken any medication today or anything that might affect your judgment? Are you happy with your counsel? Are there any questions that you need to ask counsel at this point in time? Are you guilty because you actually are guilty? Those are all things that the judges ask and did ask in this case. And he replied yes to all of them. So when you have a guilty plea like that, it's pretty lock solid. And so the only thing that you can really try to, when you appeal after a guilty plea, is whether there was ineffective assistance of counsel, whether there was some sort of Brady violation where they didn't give the information to the prosecution didn't give the information to the defense, or there's some magical proof of your innocence, right? Those are really only the three really ways. I'm sure there's other creative arguments that you can make, legal arguments you can make, but those are the real basic ways of what you can challenge your guilty plea and try to withdraw it to get a new trial.
Either you argue your lawyers were ineffective, or you argue evidence was hidden from you that should have changed your decision, or you claim newly discovered proof of actual innocence. That's essentially it. Everything else is noise. So which one is Kohberger trying to use? By his own filing, it's a mix of, my lawyers pushed me into this, and, they didn't fully explain the hair evidence to me. But if that evidence was already sitting in the defense's own exhibit list, filed by his own legal team, that argument gets shaky fast. It's very difficult to claim your lawyers hid something from you. that your lawyers themselves put on the record?
I do not see this going anywhere. Obviously, we know that the defense team litigated this case up and down, that there were motions filed for, every iteration that it seems that we publicly knew of, that they could think of in this case. And you're telling me that when we get to this plea was on the virtual eve of trial, right? That we all anticipated that this case was proceeding forward to trial, that these attorneys hid an exculpatory piece of evidence from Kohberger to get him to enter a plea when we all thought that this case would be proceeding to trial is ludicrous in my mind.
Here's a line worth sitting with for a second, D. If the people arguing your innocence are the same people who filed the evidence you're now claiming was concealed, who exactly is telling the truth here? I'll let that one marinate. Let's push a little further, because this is where the timeline stops adding up. Every post-conviction filing like this one has a deadline attached to it. A window of roughly a year from sentencing, where a defendant can even attempt to raise these claims. That window was closing. So the question becomes whether this filing represents a genuine, newly surfaced legal argument, or whether it's simply the last available move before the door shuts for good. Those are two very different motivations, and only one of them requires the evidence to actually be strong. And there's something else worth noticing. Attorneys who work post-conviction cases regularly will tell you they see this pattern several times a year. A defendant pleads guilty, time passes, and then a motion to withdraw surfaces. It's common enough to have its own well-worn script in the legal system.
I mean, I think it probably came as a surprise to the family. As in the world that I live in as criminal defense and former prosecutor, I see this kind of stuff all the time. I probably see it, 10 times a year. You'll have a guy that takes a guilty plea and then you'll have a guy that takes a guilty plea and then he wants to withdraw his plea at some point in time. So it's fairly common in the criminal justice system. So.
And what was your reaction?
Judges have seen it. Prosecutors have seen it. The families in this case have effectively been told this is process, not surprise. Now I want to give credit where it's due. To you, actually. If you've been following this case closely, and you noticed early on that this plea deal never included a full, spoken confession, a stated motive, or a detailed account from Kohberger himself, you were ahead of a lot of legal commentators. That gap. The fact that he pled guilty without ever explaining why, in his own words, out loud, is exactly the kind of detail that skeptical, sharp-eyed viewers picked up on long before this appeal ever surfaced. That instinct was right. Something about this plea always felt unfinished. The difference is, an incomplete confession isn't the same as an invalid one.
Well, you have the power in that case. If the person wants something from you, if the defendant wants something from you, you say, okay, well, I'll give it to you if you meet A, B, C, and D. And they say, well, I'll give A and B, but I'm not going to give C and D. You can either say, okay, we'll take it then. Or you can say, no, I want A, B, C, and D. And for us, it was that. It was something from him, a statement, about what happened, what he did, anything like that. And guess what that does? That just locks it in. I mean, it's even more solid of a plea, right? Because he makes a statement about what he did. These guys that go in and they plead guilty and they don't make any statements, there's this idea that maybe they can withdraw their plea at a later date or things like that. But any of his arguments none of it negates the fact that he pled guilty. There's DNA evidence there. There was plenty of evidence to convict him at trial. And nothing that I see at this time would call for a new trial in any way. And I've advised my clients that way.
Because here's what an unfinished confession does not do. It does not erase DNA evidence tied to a weapon at the scene.
But keep in mind, his DNA was on the knife sheath. The cell phone tracking tracked him to the house. I mean, there was plenty of evidence there, which I've gone through a million times. It says petitioner was convinced that actual guilt was not an important.
It does not erase cell phone data that placed a vehicle near that home in the middle of the night. It does not erase the fact that a trial was fully prepared. evidence was fully exchanged, and a plea was still chosen over facing a jury. Every piece of that stayed true on the day he pled guilty, and it stays true today. So when you strip away the legal language in that affidavit, what you're left with is an argument that the threat of the harshest possible sentence influenced his decision to take a deal. And legally, that's not new ground either. Nearly every plea deal in a capital case exists because the alternative sentence was worse. Choosing a lesser outcome over a harsher one isn't coercion. It's how plea deals work. And it's how they've always worked.
And the idea that I had to explain this to Steve, today. He's like, yeah, but he's saying that they forced him because of the death penalty. It was hanging over him. Well, guess what? Criminal cases are all that. I mean, if you're charged with a burglary in the first degree and the maximum penalty you could get is 5 years and you take a deal for 2 years, right? Your excuse is not, well, the only reason I took the deal for 2 years is because I could have got 5 years. I mean, that's his argument, right? That's the argument in the affidavit. Well, the death penalty. So what? With that goes with the crime, right? Just because you took something less doesn't mean that the maximum penalty for that crime forced you into taking it. You just got a better deal, is all it is.
Which is why, when this filing becomes 10 different debates across true crime channels tonight, I want you to remember one thing. None of what's been made public so far meets the legal bar required to undo a plea like this. But legal reasoning is only half of this story. Behind every filing, every hearing, every headline, some families thought this chapter had already closed. Families who now field phone alerts and news notifications about their own tragedy in the middle of an ordinary workday.
Things are going really well. We've got to the point where we've gotten all the paperwork done, the 501(c)(3)s and all that stuff is done. So now we have to really hone down on finding the right case where we find a family that is got a prosecutor or an investigator who's willing to reach out and talk to us and say, hey, all right, how do I use this money to find a lab? Here's my lab. Do you guys have a connection? So yeah, we're going through that. It's been very healthy for the girls to have something positive to work towards, to not just say that something good is going to happen out of something bad, but actually be making good happen. So yeah, it's been really good. It's actually been a nice relief. It's probably been more therapeutic than talking on the couch.
Families who've built foundations in their daughters. Names who talk about them not to relive the case, but to keep them present in a way that has nothing to do with the man now asking for another chance in court.
As always, I appreciate Steve for taking the time. Look, these families, when I reached out to Steve to do the interview, he was at work. I mean, he works, he's in IT. You forget that these are real people, and it's like he's at work and then he gets word that all this is going down with Kohberger. They're just trying to move on with their lives. And you can't really move on, and they've started their foundation and they talk about Kaylee every day. And it's not like they're trying to move on to forget about Kaylee, but they're trying to move on from Kohberger. And this is obviously very, very painful. They have an attorney, Shannon Gray, a victim's rights attorney. He's actually a criminal lawyer too, who has represented them through this whole process and also understands the legal side of things.
One father has said, simply, that he just wants people to remember his daughter's name. Not the case number, not the filings, just her. That's what gets lost every time this case reopens for another round of legal theater. So, here's what I want to know from you. If the evidence he's pointing to was already known to his own defense team before the plea was ever signed, what do you think he's actually hoping this filing accomplishes? Drop your theory in the comments. I rate every single one.
Will he be assigned another public defender to sort of handle this appeal process? I spoke with Edwina Elcox, and she's an attorney in Idaho that I have gone to several times since all of this started, because you have to, look, for stuff like this, there's an Idaho Supreme Court case that comes into play with about whether he can appeal. You have to go to people in the state to get it, because they're the ones who understand the state law. Just getting some attorney from another state doesn't really work in a situation like this.
And stay close, because in my next video, I'm walking through the exact state Supreme Court precedent that will determine whether this claim even earns a hearing at all. And it changes how this entire next chapter could play out.